If you are an employer who has an active office in the U.S. or wants to establish one, the L-1 visa may have the benefits you need to send experienced high-level employees to the U.S. to grow your business. However, like with many other temporary work visas, it has its advantages and disadvantages that may help or hinder your case. Read on to learn the L-1A and L-1B visa requirements as well as how the benefits apply to your business. L-1 visa benefits for foreign workers. The L-1 visa is broken down into two subcategories, the L-1A for managers and executives, and the L-1B for employees with specialized knowledge. Each has its own requirements and duration of stay. When comparing these L-1 visas with many of the other work visa classifications, you will find that, depending on your immigration situation, it has many benefits that the others do not. Relatively low requirements. There are many work visas available to foreign professionals who wish to be employed in the U.S. Many of them have very steep requirements that are difficult to fulfill. For example, the O-1 visa requires applicants to show their extraordinary ability through international awards or a substantial salary. The TN visa is only available to Canadians and Mexicans. The E-2 visa requires a substantial investment in a U.S. enterprise. The L-1 visa, however, only requires you to be a manager, executive, or specialized employee in a multinational company in order to be qualified. This opens up the door for many people that are otherwise ineligible for other work visas. No job offer required. One of the most difficult aspects of acquiring an H-1B, J-1, or TN visa is finding an entity that is willing to sponsor you for the visa. If you are a qualified L-1 applicant, then you are already employed with a U.S. company that will sponsor you. No annual limits. Typically, the L-1 visa is compared to the H-1B on account of their similarities. However, they differ largely here as there is a strict annual cap on how many H-1B petitions are approved. Each year, a small number of petitions are randomly selected from the pool of submitted petitions, making it very difficult to obtain an H-1B if you are subject to this lottery. On the other hand, there are no limits to how many L-1 visas are approved each year. This means that your petition will not be rejected due to the fact that there are no more available visas. Period of stay / L-1B visa duration. For the L-1A visa, holders will be granted an initial 3 years of stay in the U.S. They can then extend their stay to a maximum of 7 years. This surpasses the H-1B's maximum of 6 years and the J-1's maximum of 5 years. However, the L-1B visa can only be extended to a maximum of 5 years, making its period of stay a disadvantage when compared to other work visas. Educational requirements. One of the greatest L-1 visa benefits is the fact that you do not need a degree to qualify. This is a large advantage over the H-1B, though there are some other visas that do not necessarily require an education. These include the O-1, E-2, TN, and J-1 visa classifications. Spouses and dependents. If you are in the U.S. on L-1 status, you will be able to bring your spouse and children along with you through the L-2 visa, and the validity period will be the same as that of the L-1 visa holder. Also, if your spouse qualifies for an employment authorization document, they will be able to work in the U.S. as well. This is a great L-1 benefit because it allows your spouse to make supplementary income to help support the family if necessary. Only spouses can work on L-2, not children. Parents of L-1 visa holders are not eligible for the L-2 visa, unfortunately. Dual intent. Like several other non-immigrant visas, the L-1 is considered by the USCIS to be dual intent, meaning that L-1 holders are able to pursue lawful permanent resident status during their stay. This is in contrast to work visas such as the J-1 and TN visa classifications through which pursuing a green card would violate your status and possibly incur consequences with the USCIS. Here's a recap of what you can apply for as an L visa holder while physically in the U.S. Labor Certification Application. Immigrant Visa Application. Adjustment of Status Application. Application for H-1B visa or L visa extension. It really is a tremendous benefit to be able to apply for permanent residency while in the U.S. on L1 without facing negative repercussions. Moreover, one advantage over the H-1B is that employers don't need to prove that the wage meets the prevailing wage of similar domestic workers. How the L1 visa benefits employers. Applicants are not the only ones who can take advantage of the L1 visa benefits. Employers have much to gain from choosing to use this visa over others. Blanket petition. The first and perhaps the greatest L1 benefit that employers can enjoy is the fact that the L1 has a blanket visa option for companies that have combined U.S. revenue of at least $25 million or have a minimum of 1,000 employees working in the U.S. An L1 blanket petition allows employers to file a single petition for multiple employees, meaning that you will not be required to file and pay for a petition for each employee. For large companies that need to get many employees over to the U.S. with short notice, the blanket petition is an invaluable advantage. New offices. Another equally important L1 benefit is the fact that, if a multinational employer does not currently have an office or branch in the U.S., an L1 holder can be sent in order to establish a new one. While there are different limitations attached to this process, it is extremely advantageous to be able to establish a new office, and the U.S. employer will be able to send L1 holders to the new office once it has been established. Labor Condition Application Requirement. Even though it is not a necessarily arduous or expensive process, obtaining a labor condition application, LCA, for each H-1B or E-3 employee can add up in both time and money. Fortunately, the L1 does not require that you obtain this certification when petitioning for an employee transfer. L1B versus L1A, Visa Requirements. The L1A visa is designed for intra-company transferees who work in managerial or executive positions, company outside the U.S., while the L1B is for intra-company transferees who work in positions requiring specialized knowledge. L1A visa requirements. In order to meet the L1A requirements, you must have been working for a qualifying company overseas for one continuous year within the past 3 years immediately before your admission to the U.S. Have an interest in coming to the U.S. to provide your skills in a managerial or executive capacity for a branch of the same employer or a qualifying organization. L1B visa requirements. In order to qualify for an L1B classification, you must have been working for a qualifying organization overseas for one continuous year within the past 3 years immediately before your admission to the U.S. Have an interest in entering the U.S. to provide services in a specialized knowledge capacity to a branch of the same employer or one of its qualifying organizations. L1 visa restrictions and disadvantages. Unfortunately, all of these L1 benefits do not come without some drawbacks. Even though the L1 can be relatively easy to obtain, those same advantages can be considered disadvantages if you are not already employed. Must already be employed. While this was counted as an advantage earlier, it could easily be a disadvantage depending on your situation. If you are not currently employed with a multinational company that is large enough to have or plant an office in the U.S., then this could be a very difficult hurdle to surpass. This is especially true since you must work at that company for 1 full year in the 3 years that precede your entry into the U.S. No extension past the maximum period of stay. This is one of the biggest L1 visa restrictions. Even though the L1A allows for holders to work for up to 7 years, this limit cannot be exceeded for any reason. For other visas, such as the H-1B or J-1, an extension can be acquired past the usual maximum. There are even some visas like the O1 and E2 that allow for unlimited extensions. However, unfortunately, L1 holders are only granted one extension after their initial 3 years. After that, they must either transfer their status or apply for a new L1 visa. Limited types of companies. While other visas such as the H-1B allow you to be employed with any U.S. employer, the company sponsoring you for an L-1 visa must be a multinational company that either has or is planning to have a branch, subsidiary, or office in the U.S. This rule usually excludes businesses that are too small to have international branches as well as small business owners. Make sure to speak with your immigration attorney to determine if your business qualifies for this visa. Entrepreneurship. Another L-1 visa restriction is the fact that visa holders are not permitted to start their own businesses while on L-1 status. In order to maintain your status, you must only work for your sponsoring employer and no one else, meaning that you also cannot work part-time for another employer simultaneously. This is in contrast to the H-1B visa, which allows both entrepreneurship and part-time employment. Procedure to file. In order to get the process started, your employer should review and complete Form I-129, petition for a non-immigrant worker. Pay applicable filing fees. Submit the required evidence and supporting documentation. This includes a duplicate copy of Form I-129 and all supporting documentation, even if they are filing the Form I-129 to seek a change of status, COS, or extension of stay, EOS, on your behalf. After USCIS receives your Form I-129 and they process it, you will receive a receipt notice confirming they received it, a biometric service notice, notice to appear for an interview, if necessary, and finally a notice of their decision.